Probably sure about it, so they just have
I'll get you a regular flag.
Oh, yeah, I mean, that would make sure. Thank you, Mark.
That's joy.
No, that's fine.
What we call you.
That's everybody.
All right.
Oh, yeah. You walk in there and you got Michael.
Why is that you? I bet
Are you staying down in the room? Staying in the room? For me, too nice. Oh, yeah. Oh, well, west of that. Yeah. Mom, that's house, it was just handy, but the whole outside had to get it done. It'll cover like a little small fish shack, right? We've got a couple houses. Right there. Can't beat it.
No, you know, if it rains, it's not here.
Yeah, we did. Yes, yeah. Yeah. There's a right. You know what rights is.
Yeah, I can make it.
We'll gotta get the rights.
Yeah. No, no, but yeah, my plan would be that's pretty nice. Do it. I think, you're right. Be off.
You're in a very small.
Yeah, y'all got. Isn't that weird? I know.
And dedication is to go down.
That's right.
They're giving that. No.
What I was at the state.
That's driving over.
That's just a lot.
Right here on the road. That's right. City, right. So they had a couple of Lewis, a couple meetings. Tree free.
We're certainly trying.
Yeah.
Before I became an attorney, I was.
I'd be doing the same thing.
I wanted to get more.
This meeting is set up business and take that.
But I had some free songs.
The big tree, I bought my house in March. It came with this enormous vegetation, enormous tree in the backyard. It was this way and then a huge branch over my neighbor's house. I was like, wow. I should probably do something about that, but. Amount of money.
Or you all said, everybody survived all the storms in the week or two, so we are very good. We're getting talking about that already. I'd like to call the meeting. of the-
Recording in progress.
Motor vehicle to get, the order. Time is whatever, I guess Alexis, she'll put that down. We want to welcome our newest person that will be helping us with AG's office, Aaron Lowry, so thank you. We thank you guests and people that are already here. I know some of you, so we'll talk with you all a little bit later. I guess we need to start with the approval of the Wednesday, April 16th, 2025 meeting. And if you all don't mind, for recording purposes, state who makes the motion and who says the second. We will do a roll call and that will help everybody. I'm Joy Blankenship from Pine Bluff.
Michael Johnson from Russellville. Gerald Saber, Wright. Scott Wood, Batesville. Jimmy Jones, Fort Hays.
Lev Bradford, Renee TV.
Michael Muskelly, Mitchell Blackstock, Louisville.
Trevor Hopkins, Mitchell Blackstock, on behalf of Bradford Marine.
Willie Andel, Quattlebaum Grooves and Soul on behalf of BRP.
Brandon Rosansky from Barrett, Verrazano, Kirschbaum, and Nagelberg in Chicago for BRP USC.
John Aquilino, investigator, motor vehicle commission.
Margie Sexton, investigator.
Alexis Dunlap, licensing supervisor.
Aaron Lowry, Attorney General's Office. Daniel Pace, Director of Motor Vehicle Commission. We have
Michael Moix, Commissioner from Conway, Arkansas.
Is that
Clay
Clay?
Maxey from Mountain Home.
Thank you. Thank you all.
Thank you, Clay.
Yes.
All of us.
All the commissioners are here. So now I'll entertain a motion for approval of the minutes for Wednesday, April 16th, 2025.
Motion to approve, Michael Johnson. Second, Jimmy Jones.
Moved and seconded, we approve the minutes for Wednesday, April 16th, 2025. All those in favor say aye.
Aye.
All those opposed, same sign. Motion carries. So you just want to go on to the financial review approve those? All right. So I'll turn it over to you, Director Pace.
Thank you, Ms. George. All right, so we are getting into the last stretches of the month of May of fiscal year 2025. So the first list and report you see here is all of your deposit revenues for 2025 fiscal year. And as of this Monday, the 19th, last deposit, we were up to 425,942.49 on the year in revenue. So, and again, we have another, month and a few weeks. I do anticipate we'll end up somewhere in the 430 to 440 range, just based on historical precedent of manufacturer reps, distributor reps, a few dealers trickling in, a few manufacturer distributor licenses coming in the last month before the manufacturer distributor renewal process starts. We always have some people that trickle in at the end of the year. So that's probably where we'll end up. That's where we're at right now on revenue on the year. This second reports here that Alexis puts together for you guys are great. The first list is obviously the 403,201,000 account number. That's all of our late fees and penalties on the year. So that's for the entire fiscal year. See that number there down at the bottom. That's all of our late fees and penalties for fiscal year 25. That next list is fiscal year 25 license and permits revenue. So we've got to divide it out, license and permits and late fees and penalties. That number at the bottom of that list on the next page is our license and permits revenue on the year so far by date. And then the last revenue report here is just basically since I believe the time of the last meeting, right, Alexis? So that's just since the last meeting in terms of revenue we've had since the last meeting. And then your more detailed monthly service bureau reports as of late last week has obviously a breakdown for the entire fiscal year, all of our cash investments, license and permits revenue. You can see that 1.5% fee that's deducted by DFNA there as well. This is also going to give you a total breakdown of expenditures by month, where we're at there. And also interagency transfers, where we're at with operating expenses. Obviously, you can see we're in a good spot in terms of our fund balance. That next page of the Service Bureau report is going to have our appropriation, just gives you an idea of where we're at in the month of May in terms of remaining appropriation. And as you can see, we still have more than enough in terms of salaries, personal service matching, operating expenses, all of that left for the last month and, what is it, a couple of weeks in this month. So, we're not going to come anywhere close to needing to go to the legislature and ask for the appropriation this year. So we're in good shape there. The rest of this is just a detailed breakdown of all the salaries, expenditures, basically everything that has been expensed for the commission this year, including board reimbursements and stipends. And also, you know, like I said last time, John's computer that we had the purchases on there is the surplus, our yearly annual fee for the ELP licensing software is on there. Basically, any expense that we've had is on there in detailed breakdown for you. And we have everybody finally on, in terms of the travel reimbursement, we've got everybody on direct deposit now with that, except Mr. Boyes, which we will get next time he's in person, so. I'll make sure we get that done, but everybody else is on the deposit now, so no more wants for anybody. And then your last two reports here is just kind of a summary report by fund for both revenue and expenditures, just kind of an easy to digest breakdown of everything month by month and kind of where we're at the moment. And again, these reports on revenue already have the 1.5% fee deducted from on the summary and then expenditures with our appropriation there. So all in all, we're in really good shape. Again, I expect we'll have a little bit more before next month's meeting. But we'll end up emerging 4:30. We don't have any issues.
That's right.
So,
Great report. Anybody have any questions? I think the way we've done this, I feel like it's good, putting it in where we can manage it and see what we're up to. So thank you so much. I'll entertain a motion for approval of the revenue and expenditure for fiscal year 2025.
Scott Wood, I move that we approve the revenue and expenditures report. Darrell, second.
Been moved and seconded to approve the revenue and expenditure report. All those in favor say aye.
Aye.
All those opposed, same sign. Motion carries.
I'll move this into our licensing reports, that Alexis puts together for us. So this is since last time. So the first page here is just our detailed submission dashboard. This is from our ELP system. Just to kind of give everyone a breakdown of license type, submission counts, all of that. That's just a master breakdown. On the bottom list is, I believe, Alexis, since the last meeting, basically, in terms of applications we've received, right at the very bottom. So that's a summary report for you. That's great information that Alexis can put together with our reporting system. So next we have all of the new licenses that the commission has issued since the last meeting in April. So the first one here is very small Extreme Outdoors. This is a mountain home-based dealer, off-road outdoor products dealer in Baxter County. And he's selling Segways at this point. Segway UTVs, that's the only product he's selling. But he did have to get a license from us to sell those. Issued him a license in the last one. The next one is Heartland Honda by Wood Power Sports. So this is in Springdale. They're selling Honda motor company ATVs, motorcycles, utility vehicles. This is one of the premier Honda dealerships in the state. It's been there for a long time. This was previously owned by the Donahue, right? Alexis Donahue, Greg and his family.
Yeah.
And they have sold to Wood Power Sports. So Wood Power Sports Group owns this dealership now, but it's staying in the exact same spot. They didn't move it. Obviously, they're not moving or relocating anytime soon. But since the ownership changed, we do still have to issue a new license because it's brand new owners and a new corporate name. So, but otherwise, everything else is staying the same. Market area is staying the same. Nothing else changed. Just the ownership of the dealership. So, and they're still keeping Heartland Honda in their name, just Heartland Honda by Wood Power. The next one is Master Transportation of Arkansas. So this was a dealer. It's a commercial truck bus dealer. They've been around for a while, but they were originally located in Hot Springs, Alexis, right? They moved from Hot Springs to Cave Springs. So obviously that's, halfway across the state. They've got a brand new location up there in Cave Springs. John actually went and did an inspection and everything's in good shape. But they mainly, they just sell buses, basically, different buses. But they've got a nice building facility up there in Cave Springs. And so since they obviously relocated outside the county, and since they had to get a new license, so we issued them that new license number during the last couple of weeks. They're still keeping the same business name and everything. And now they're in Cave Springs, which is in a different county as opposed to Dartmouth. So, and then the last one on the list here is Walt Massey Chevrolet in Franklin County in Marion. So in this case, this was Holly Chevrolet for a long time in Marion, and the Walt Massey Automotive Group, which has dealerships in Mississippi, Alabama, kind of all over that area, bought that dealership here recently. GM approved that here in the last week, so we were able to finally issue that license, and they're just selling Chevrolet there, just taking over that location. And they've already got all the signs changed and everything. They were, Margie went to do a dealer visit, and they had it all changed that day, once they approved the contract. So, it's now Walt Massey Chevrolet instead of Holly Chevrolet. And those are the only four that we've actually approved some more in this week, but we didn't have time to get those impacted. They'll be in the next packet for the next meeting. But those are the four that we have for you here in terms of new license approvals. This last list here, it's color coded for you. Alexa put this together. So this just shows you in terms of dealers, we only have 2 dealers that have not renewed at this point in the system. Out of all 500 plus dealers that are licensed, there's only 2. One of them is Moped U in Fayetteville, right, John? So in this situation, this lady's husband passed away a couple of years ago. She still owns the dealership. She's not really interested in continuing to own it. She's trying to sell it. We tried to get her to just go ahead and renew. There's some issues with insurance. We're trying to figure it out. We think she's in the middle of selling it to another couple of individuals. John has actually talked to them and visited with him, but we just haven't been able to confirm that yet. So it's very likely that this will have a new owner soon, which we'll have to approve at the next meeting, but we're still in the process of that. And then our friends at White River ATV, for whatever reason, they'll relicense them at a new location. That the commission requested, and they did everything there, but we cannot get them to resubmit the renewal so far. So I don't know if we're gonna have John go pay them a visit or what, but that we've called them, we've emailed them, we tried everything, and they just have not done it to this point. They submitted their original application, right? So they submitted an original application for renewal, but they were lacking a bunch of documents, so they sent it back to them. So they did pay, they just haven't completed the process. And then the rest of the list here, these are manufacturers and distributors that we believe are probably out of business or no longer going to have a license with us, or that gets removed from them. One of them has indicated, I think it's Start Future, that they are interested in renewing their license. Obviously, they would have a lot of late fees if they do. That gentleman has called us several times and said he's going to do that, but so far he hasn't called. So, and then the last list here is all the voluntary license surrender agreements that we have outstanding that we still need to approve. Now, Holly Chevrolet, we do have that one that'll be for next month, so you can kind of mark that off your list. That'll be approved next month. We just didn't have time to get it in the packet. Margie is working on Bruno's Power Sports. She's going to go pay them a visit there in Cabot. They're still open. They're just not selling Power Sports products anymore. And then a few of these other ones we're still working on. But this is the final list that we have. We're down to single digits. We started out obviously with how many of these have we done last year? Just probably.
Well, last year was 90.
Yeah, so we've done quite a few of these. We've got down to just these people that we still have to do. So and that's pretty much it for the last short. Not as long as some because we only have months. So.
Right. That's great. That's good.
You're part on the with Power Sports.
Yeah.
The other 10% on there, you've only got 90% down here.
Yeah, I believe that's, isn't Blake the 10%? Yeah, Blake Young is the 10%. Yeah, it's not, I don't know if we may not have enough room on there.
Yeah, you've got him on here. You've got a 50, a 20, a 10, and a 20.
Not adding up.
That's how they listed it. I will contact.
There's another one.
Figure out what's going on.
We'll figure out. There is. Yeah, you're right. We'll follow up, but there is some.
I will send out an update in that.
Yeah. I didn't see that.
Well, any questions? Let's start the court. Got like that, you want to go into the investigative summary?
Yes, ma'am. I will turn this over briefly to Martin John. You guys just want to give a quick update to the commission on your investigation summary reports for this month.
All right, well, so far this month, I've got 10 open investigations, this is totals. 1 pending and 10 closed, for a total of 21. There's 3 open formals, I'm getting ready to close one of those, 1 pending. 1 closed, and then non-formals, I have 6 open and 10 closed. And then 1 ad investigation.
And on mine, I had 6 open, 10 closed. That has changed. On the formal, I still have 1 open, and then I closed 1. And on the non-formal, there were 5 that was open. I added 2 and I closed 2. So, well, I guess it's still the same. 16.
And between the two of you, y'all did 24 dealer visits
Yes.
in the last month.
So,
Yeah,
They've been busy.
they've been busy. They're gonna stay busy. Move on. So. All right.
Yeah.
That's what I'm talking about. All right, so that moves us to our consumer assistance complaint reports. This first list you see here is our 2025 formal complaints. Margie and John have been working really hard on these. We've been getting these closed out pretty quick. The only ones we really have open are the James Brady deal, and that's pending an ad hoc committee review, which Aaron and I are going to need to complete. And this is one that I'm not going to get into that, but basically it's going to be dismissed unless Aaron and Joy have different thoughts than I do. And then we have Ms. Collins that Margie will probably be closing out pretty soon, I believe.
Right.
Yeah, she's got until the end of the week, early next week to respond back to us. And then the only other one that's open currently is this new one for Mr. Haskins, it's RV City, which we're working on. And the Queen Auto Group versus Stellantis, I think, based on the conversation John had with their attorney earlier this week, so we might be able to get that one resolved pretty soon. So hopefully we'll be able to close that one out, get that one resolved here in the next week or two. I think we're gonna have a positive result there for the dealer. So let's keep our fingers crossed on that one. That was over a dispute over some warranty work that they did, and there was a reimbursement, and then they charged back the reimbursement, and there was some stuff that went on there. I think we're gonna get a positive result. I think there was a mistake. So, but we're working hard on that one. John's working hard on that. The 2025 non-formal list, obviously it's gotten pretty extensive. I mean, we're not even into June and we're already up to numbers wise, find the window here. Yeah. 58, yeah, we're almost to 60, yeah, almost to 60 on the year. So, and John and Marty have been working as hard as they can to get them closed. Obviously, again, non-formals can be anything, emails, phone calls, something Marty and John see when they're out traveling, referral, and someone just sending us some information, something that somebody gets in the mail, and it could be anything. So, a lot of these are dealer site visits and inspections as well. So, they've been doing a great job working through these, getting them closed out as soon as possible. If it's not closed and then you see it's a little earlier in the year, that's probably because it's a title issue or something along those lines that John and Marty are having to constantly follow up on to make sure that the dealer gets that title. So, but for the most part, we work through these pretty quick. You'll see a lot of visits on here that will probably be closed out by the time we come back next month. So, let's see, I've already got Mr. Brady on that list for Joy and I here to deal with. And then we have our 2024 list. Obviously, Bradford Marine and ATV is still open. I'll list that. And then there is a couple at the very end of 2024. That's why I still have this in here. Gentry Chevrolet, which we're going to address a little bit today. And then the Central Arkansas Mahindra, the Argo complaint. John worked hard on that with counsel from Argo and Mr. Landry from Central Arkansas Mahindra, and we got a great result there. I think we got a resolution that everyone's happy with. We should be able to close that out pending final confirmation of credit balance for parts, I think. That's what we're waiting on. So we're almost done with that. We should be able to close that out, and that's not something that's going to have to come before the commission. So, and with that, that's pretty much my report on complaints. Mr. Williams, does anybody have any questions about anything you see there?
Anyone after reading it have any questions? Certainly not get to add complaints we should get, so. That was a whole.
Better knock on wood. Say that.
Don't say that. Oh,
No, but you are correct. We have not gotten as many ad complaints now. John and Marty do a lot of ad reviews and education to try to help.
yes, I was gonna say, you ought to stop it before.
We try to
It's,
preempt. That. But we do still occasionally get them, but we haven't had it.
Yeah, and we used to get. Good deal. Yeah, those are good reports. So thank you all. Thanks for the hard work that all of you all do here. We appreciate you.
Thank you.
Okay. Aaron and Daniel, I think we're going to turn this over to you for legal briefings and then a hearing update.
All right. And, we want to start with, obviously, the first, section A there, Bradford Marine ATV. So I'll let Aaron facilitate a lot of this, but, Mitchell Blackstock has submitted a request for continuance, which you all have seen in the packet and that letter. And then, Brandon and William down there on behalf of BRP have also sent in a letter of opposition for you guys to review. And that's kind of why we're here today. That's why they're here. I don't know if Aaron wants to kind of turn it over to them first to let them kind of explain the need for both, both the letter request for continuance and then the opposition letter, and then we can let Aaron say that shows. Trevor, do you want to go first?
Yeah, certainly. I'm Trevor Hopkins. I'm from Mitchell Blackstock. I don't want to belabor this whole lot. I want to be respectful of the commission's time. But a lot has developed even since the letter was originally sent. So I just want to kind of give a quick rundown of, historical context and where we're at now and why we still are asking that the commission approve this request for continuance to provide more time. So I believe at the January meeting, it's my understanding, we did not represent Bradford Marine at the time, that it was explained to the commission that the parties were working on trying to work this issue out. And since then, there was, I believe it was represented, some information was submitted to BRP at the time. The parties then had a meeting at the end of March together to discuss this. I believe that as fair as possible proved futile, and so we came on. We were hired to represent Bradford Marine. We got to work immediately in the month of April, responding to the discovery request. We prioritized that to get BRP the information that they'd asked for. The following week, we sent discovery requests to them, and we tried to meet and confer in between all along the way. We were on a marathon run starting this last Wednesday BRP deposed 3 of Bradford Marines, people related to Bradford Marine or Bradford Marine employees. We received discovery responses from them and deposed a representative from BRP yesterday. We have more questions and answers in some respects with some of the things that we've learned in this short amount of time. And I don't want to litigate those here in front of the commission, but it's suffice to say, you know, this is an administrative hearing. The legislature has put it on the commission to hear this matter, make a determination of whether good cause exists to allow this dealer to come into Bradford Marine's relevant market area. And I think it's on us to work out to make sure both sides have all information pertinent to present to the commission, so that y'all can make a decision in this matter. And so in a nutshell, that's where we're at and why we're asking the commission to move the timeline, to give us an extra 2 months to meet and confer, work things out, and I really believe we can. Otherwise, you know, I think, you know, we'll start having to make motions to the commission and ask for more formal decisions relating to information that we learned. That's all I have, and I think everybody else talked.
And Trevor, just to clarify, so Mitchell Black's like you guys were hired, good?
We came on the beginning of April.
Brandon?
Yeah, thank you for your time and attention to this matter. The sole basis for why Bradford Marine is seeking a continuance of the pre-hearing schedule and the hearing schedule is that they failed to exercise any reasonable level of diligence in pursuing what's called fact discovery from BRP. They are now seeking from the commission a chance to escape the consequences of their failure to exercise reasonable diligence in pursuing fact discovery and seeking to cast blame on BRP for their own lack of diligence. The commission should reject Bradford's request for a continuance for several reasons. Back on November 21st, 2024, the parties through counsel, Bradford was represented not by these gentlemen at the time, but had counsel, Mr. Will Allison. He agreed with me on a pre-hearing schedule that would provide the parties the chance to take what's called fact discovery from each other and set a schedule for expert discovery as well. Because these types of disputes where the manufacturer is seeking to add an additional dealership often come down to opinions given by expert witnesses. And we had set a schedule that would allow for kind of 2 phases of what's called discovery. The first phase would be fact discovery, and that was going to be completed by May 9th. The next phase was expert discovery, and that would be completed by August 15th, with BRP's initial expert reports to be due May 30th. That was submitted to the commission, or to the commission's counsel, or the Attorney General's representative for the commission at the time, Michael Bynum. That was submitted, I think it was November 25th, 2024. So we've had that schedule blocked out, set as early as November 21st last year. We came before the commission for a meeting on January 15th with a joint request to adopt that schedule, have the commission kind of approve that pre-hearing schedule, and also the hearing dates, which were set for September 30th to October 3rd. At the time, we were jointly making that request because the parties decided to pursue, see if the case could be resolved through settlement discussions. But we still needed to have the hearing schedule and the pre-hearing schedule set in case those settlement discussions did not pan out. And that happens to be the case. They did not pan out. There is no settlement. There has not been a settlement reached. That's unfortunate, but that's the parties had planned for that contingency and came to the commission knowing that that might be the outcome. We asked the commission to set those dates. We explained at the meeting we were at on January 15th that these cases will entail a significant amount of work to obtain fact discovery. Fact discovery consists of the parties serving on each other requests for documents that are relevant to the claims and defenses, requests, certain questions that can be asked in writing, and then certain questions that can be asked through what's called a deposition, where somebody, from each side or multiple witnesses from each side answer questions. That was set to be completed, not started, completed by May 9th. And then the expert discovery would ensue. And the reason for staging, as the parties did, was that the parties would then have the opportunity by May 9th to get the documents and information they think they might need. And then they could pursue expert discovery with their expert witnesses on the topics that they think matter. And the experts would have the benefit of having the parties' efforts during that fact discovery period of getting documents and getting responses to questions. On January 15th, the commission approved the parties' pre-hearing schedule and the schedule set for September 30th to October 3rd for the formal hearing. BRP served its document requests in interrogatories on February 25th. That meant that the responses from Bradford Marine would be due March 31st, well within the time frame of the May 9th fact discovery cutoff. Bradford Marine did not serve discovery on BRP at that time. Bradford Marine was represented by counsel at that time. On March 12th, the parties held a formal settlement conference with each other, and attorneys were present. Mr. Will Allison was present on behalf of Bradford Marine. Bradford was there as well. It was a virtual meeting. The parties discussed to see if they could reach a resolution, which was a continuing dialogue for many months. And ultimately, a resolution has not been reached. During that call, BRP's counsel, my colleague next to me, invited Bradford Marine to serve discovery requests on BRP. Bradford Marine did not do so. On March 24th, just 7 days before Bradford Marine's responses to BRP's discovery request would become due, we received an email from Will Allison asking for an extension of time, for a 21-day extension of time to respond to BRP's timely discovery requests. BRP responded the very next day saying, look, the May 9th discovery cutoff is coming up awfully fast. A 21-day extension would put that really close to that deadline and also cut into our time for our expert reports. But as an accommodation and a reasonable showing of good faith, we would allow a 14-day extension to April 14th. In exchange, we requested and received approval that our expert report, BRP's expert report, would not become due for one additional week. So from May 30th to June 6th was the kind of compromise. We allowed them a 14-day extension on their responses. In return, we got a 7-day extension on our expert reports. At that point in time, that was March 24th. Bradford Marine still did not serve any discovery requests on BRP. On April 14th, Bradford Marine did serve its discovery responses. And it was not until April 16th that Bradford Marine first served discovery requests on BRP. Now, under the rules, you count 33 days from that, which is the time frame for BRP's response, and that goes all the way well past May 9th. And the May 9th deadline was a deadline to complete that discovery, not to start it. The parties engaged in a discussion about that timing, and ultimately, Bradford Marine requested an extension of the fact discovery deadline. The request that came in was to extend that deadline to May 23rd. We agreed, BRP agreed to a reasonable accommodation that we would agree to extend that fact discovery deadline to May 19th, which would allow for BRP to provide its responses to the written discovery requests that Bradford Marine had served. They would become due May 19th. And they would then have the opportunity to have those discovery responses from BRP. On April 20, and so that was agreed to extend to May 19th. On April 22nd, Bradford served a second set of discovery requests. Again, April 22nd, for count 33 days, it's well past the May 9th fact discovery cutoff. And it's well past even the deadline for fact discovery that Bradford itself proposed, which was May 23rd, and which BRP agreed to May 19th. It's well past both of those dates as well. BRP is not obligated to continuously respond to a barrage of requests that come in untimely. The commission had approved a pre-hearing schedule with set deadlines for completing fact discoveries. Bradford Marine chose not to start its process until well after any reasonable deadlines, and then would put BRP in the position of not having the full time to respond within the fact discovery period. That is entirely prejudicial to BRP because the whole point was to complete fact discovery and allow for the parties to engage in expert discovery without the distractions of fact discovery. On April 24th, and this is absent from Bradford's motion, Bradford served a notice of deposition for BRP's company representative to sit for a deposition and respond on 16 different topic areas that Bradford believes are somehow related to this case. On April 25th, and BRP agreed to provide that witness. On April 25th, Bradford filed its motion. What Bradford's motion is more notable for is what it omits than what it includes. Bradford's motion does not include any of the foregoing details that I just gave about the entire process, where BRP has bent over backwards to accommodate late served discovery requests from Bradford to provide responses and documents despite no obligation to do so because of the fact discovery cutoff. But BRP agreed to reasonable extensions, and BRP agreed to have a company witness sit for the deposition. Bradford's second, it appears what is at issue is maybe this Bradford's second set of discovery requests. However, Bradford has no basis whatsoever for having served those second set of discovery requests. As I mentioned, they're way too late, but also it's obvious that they are starting to get into or trying to get into issues that have nothing to do with the commission's task at hand. The commission's task is to determine whether good cause exists for adding a Can-Am dealership for the ATV line, for the side-by-side vehicle line, and for the three-wheel on-road vehicle line in Conway, Arkansas. What Bradford's second set of discovery requests gets into is how BRP determines the warranty labor rate, how BRP determines product order quotas for Sea-Doo personal watercraft, a product that is not even governed by the Arkansas Motor Vehicle Commission. The discovery requests are plainly beyond the scope of any reasonable view of relevance. And in a word, they're intended to harass BRP and cause the expenses that BRP has put into this case to increase, to cause distraction to BRP when it should be focused on, when BRP's focus should be on preparing its expert reports, and they're simply improper discovery requests. BRP has no obligation to respond to those requests where its responses would not be due until after the fact discovery cutoff, even as agreed by the extended time frame. Bradford Marine in its motion claims that it timely served discovery requests, but it cites no authority whatsoever, no case law, nothing in its motion for the basis for that statement. BRP, on the other hand, has cited both state and federal cases in its opposition, explaining that courts regularly assume that when the court sets a fact discovery cutoff, that the parties are going to serve the requests with sufficient time for responses to become due before that fact discovery deadline closes. We cited 2 federal cases and an Arkansas appellate court decision that confirms that courts do this. In fact, courts typically do not even hear disputes over discovery that happens after discovery deadlines have closed. Bradford is coming in without any authority, now requesting to disrupt the schedule that was agreed with council, that we jointly came into the commission and requested, and is now trying to create delay. In these types of cases, delay is a tactic by the protesting dealership. It's all designed to have delay before that dealership can be appointed. The longer the delay, the only party that benefits is the protesting dealership, because it delays when that additional dealership can be approved. So the delay tactic here is unilateral. BRP has followed the schedule, has done what it needs to do. Bradford is now coming into the commission, asking for the commission to save Bradford from its own lack of diligence, without any basis whatsoever and without any explanation for the delay. We realize that council was recently hired. That is not a basis for a delay. That is not a basis for a continuance. Bradford had counsel at all points in time. In fact, Bradford's counsel filed the protest that started this dispute in February of 2024. Bradford's counsel, Will Allison, is who we were discussing settlement possibilities with pretty much since early on in that filing. Bradford's counsel, Will Allison, is who agreed to this pre-hearing and hearing schedule and came to the commission meeting with us to jointly propose and have the commission adopt. There is no basis now to say that Bradford's own delay in serving discovery requests and pursuing discovery from BRP, all the while BRP was obtaining discovery and serving Bradford with discovery, there is no basis for them to see any sort of delay or continuance on these dates. They have no reasonable explanation for that. For all of those reasons, the request for a continuance should be denied.
Members of the commission, you do have the power to grant the continuance or deny the continuance. That's inherent in the statutes that govern this commission. Typically, in court, it's going to weigh the prejudice to one side versus the other, as far as whether it's more prejudicial to Bradford if you deny the continuance versus it's more prejudicial to BRP if it's granted. So that's the question for the board. Who's going to be harmed more by granting? As long as you make a finding that it's going to be in the best interest of justice, grant the continuance, or it's not going to be denied. As long as you state that on the record and the reasons why you want to grant or deny the record, that should be enough to survive any sort of judicial challenge. This is a field circuit court. As long as that reason is on the record, that's what the commission is asked. That's right, and you can ask the parties questions to figure out this.
Why are we here when there's a 30-mile radius and you're wanting to break the radius to put a dealer inside of the radius when it's been an Arkansas law for years?
The 30-mile radius does not prevent a manufacturer from adding a dealership. It sets up a potential dispute where an existing dealer within the 30-mile radius has a right to file a protest, and the manufacturer is then put to the task of demonstrating that good cause exists to add the additional dealership. And so the commission is tasked with, because Bradford Marine has filed a protest challenging the addition of a dealership within the 30-mile radius. I think it's about 21, 22 miles away. Bradford has filed a protest that then sets up under the Arkansas Motor Vehicle Commission statute that the commission is to determine whether under the existing circumstances, whether good cause exists for the dealership to be established. It is not a prohibition on adding a dealership within a 30-mile radius. It is merely a setup where If it is within that 30-mile radius, the existing dealer within that radius has the opportunity to file a protest and ask the commission to hold a hearing on whether good cause under the existing circumstances exists to add that dealership. It is not a foregone conclusion that a manufacturer cannot add a dealership. The statute sets up the right of the manufacturer it doesn't prohibit the manufacturer from doing so. It gives the existing dealer the right to come and say, hold up, we want the commission to hear the parties and determine whether good cause exists under the existing circumstances. The statute then lays out 6 different factors that the commission shall consider. So there are a set of factors under the statute that the commission must take into account in its evaluation. Several of those factors look at the public interest and the public welfare. One of the factors looks at the permanency of the investment of the existing and proposed dealer. Another factor looks at whether the proposed additional dealership will increase competition and therefore be in the public interest. Another looks at whether the existing dealership is providing reasonable adequate customer convenience and adequate competition. And so those factors are what the parties are working with, working to find information from each other and working with their expert witnesses to be able to come to a hearing, which was the date set September 30th to October 3rd, to present evidence to the commission members on those points and have the commission take in the evidence, come to a decision as to whether good cause under the existing circumstances has been established. And then another factor that I didn't mention is growth in population and in registrations of motor vehicles. And so, the parties come in and put on their positions as to whether the additional dealership can be established for good cause shown. And that each party is going to have its own viewpoint on that. But BRP believes that the evidence will show that sufficient opportunity for Can-Am line vehicle sales exists in the Conway area without having a significantly or any sort of negative impact on the existing dealer. And that BRP believes good cause exists to have an additional dealership.
Today, we're not trying to determine those.
We're not.
facts.
We're not.
That's all we're trying to determine is
Just
whether or not the
continue.
schedule should be altered.
Right, that's correct.
And again, this is the schedule that those parties presented jointly. It's correct.
And if I may, one additional point. This is, the commission originally set this hearing in July of 2024. There was, I believe it was reset for hearing a second time for January 15th, 2025. And that's when the parties came in jointly to say, could we do a third extension to September 30th, 2024? By statute, the statute requires that with absent a waiver of both parties, the statute requires that the hearing must take place within 180 days. Okay, 6 months roughly. Right? We're now, this protest was filed in February of 2024. We're looking at a hearing based on the previously agreed joint motion that sets it for September 30th. So that's, well past the 180 days that is by statute. Now, the parties did jointly come together and waive the 180 days. But as guidance, the statute itself says these things should be determined fairly quickly, 6 months, roughly. The parties have waived that. And then the parties aligned on September 30th of this year for the new hearing dates. They're just trying to keep pushing that down the road without any basis, truly any basis for their motion. Two other points. In the cover email about this motion that's in the packet. It's in Yeah, I'm looking for it. Yeah. So it's it's legal briefings tab. The first 3 pages are the letter from Bradford Marine, and then the 4th page, the double-sided 4th page.
The one that says dear commissioners and director pay.
Dear Commissioners and Director Pace, and it's signed off by Trevor Hawkins at Visual Blackstock. April 25th, that's correct. So this was the cover email. The second sentence says, as detailed in the attached letter, this request arises due to unresolved discovery issues between the parties. It doesn't detail in the motion what those unresolved discovery issues are, but as I explained, BRP has bent over backwards to provide documents, responses to their first set of discovery. As Mr. Hawkins let you know, the deposition of BRP's corporate witness took place yesterday. There is no explanation of what the unresolved discovery issues are that form the basis for their motion.
I'd be happy to, explain.
Excuse me, the last point is the prejudice to BRP. As I mentioned, any delay in this benefits only Bradford, and it delays when BRP can have, can demonstrate good cause and have a dealership opening conduct. It also prejudices schedule, right? So we have made other plans for other matters based on this schedule that was approved in January. The schedule that they have proposed is to have this hearing take place at least 9 weeks later into the first week of December. I, as counsel for BRP, have another matter scheduled for hearing on November 18th to 22nd in another matter. The way they're proposing this schedule does not work for that. And so the prejudice is that we have made plans for other matters based on the idea that this schedule would pan out. There, absent any legitimate basis for coming to the commission for a continuance, there's no good reason to have to adjust this schedule. And so BRP would experience prejudice from the need to have delay here, or the reported need to have delay.
If I can respectfully respond to Mr. Fernandez's narrative, as I said, I'm trying to be respectful of time and not belabor this, but as I mentioned, there's a lot we know now that we didn't know even when I originally sent this letter to the commission. Every discovery request we've sent met with every single one. Objections, the 30B6, they objected every single one. They produced 1,052 pages of documents and redactions that I have to use a magnifying glass to read. There's a lot of questions with that stuff, and like I said, I think we can work those things out. But we need time. The parties have waived that 180-day deadline. The importance now is making sure that both sides have all of the information necessary to present to the commission so the commission can do its job and determine whether good cause exists or not. And Bradford was dealing in good faith, working really hard, as Mr. Allison's email says, as attached in Quattlebaum's email. They were fully focused on discovery. Well, we know now that was never an intent of BRP. That's our position. And so we believe Bradford was just being strung along. And so, maybe we work things out, maybe we don't, but it would prejudice Bradford if we don't have opportunity to conduct full fact discovery. There's a lot of questions, like I said, that I think we can work out that we don't have to concern the commission with. But if not, then we would have to file motions to address those things. And so that's why we're here in good faith to continue dealing and work this out. It isn't some ambush or there's a lot of misrepresentations I don't agree with from BRP there. We were diligent and got them the information they asked first and then tried to deal in good faith to get it back up. We conferred before we even made this motion to the commission. I told them before I sent it that I was going to, since we couldn't agree to something that was our only option. So we're here in full respect of the commission. And I don't believe, given that the 180-day deadline has been waived, the commission is under any obligation to rush through this at this point. And a 2-month, continuance, or whatever the commission deems appropriate. It doesn't necessarily have to be, 2 months, but I don't believe that that greatly prejudices, BRP, the manufacturer in this case.
And that's the issue before the commission, deciding which side is going to be more prejudiced, but they don't have to go with the requested amount. They can do a shorter continuance, they can do a longer continuance, whatever the commission needs.
As for, we've got one attorney that wants it done now. We've got another attorney that wants to pass. Where do we come into this? That's something they need to work on, not us. They said it's already been waived, the 180 days.
Well, the 180 days has been waived. I think the issue of the continuance is on the original due date for the discovery. The discovery was due on May 9th. And they're asking, and they extended that, I believe, to May 19th. That's correct. And then they're wanting a further continuance or July 18th, I think is what they asked for. So what they're asking now is an additional amount of time to exchange information with the two sides. And they're asking for that until, what was it, July 18th? July 18th. So the commission could say, we're gonna let you continue to exchange information until July 18th. You could say, we're only gonna give you until June 1st, but we're not gonna give you any more time. You should have done it. So you can have a close and middle. You don't have to, I mean, this is the deadlines that Trevor is presenting. Yeah, the commission can decide to give less time.
So we could extend the deadline for fact discovery to say June 10th. And leave all the rest of the dates where they are.
You certainly could make that decision. Yes.
I personally don't. I can see how one side or the other is going to try to drag this thing out forever.
It is not in BRP's interest to drag this out. BRP is interested
No, I know
in getting this.
you'd like to have a dealer in Conway so you can sell more
Right,
product.
right. And so just to clarify, we're not seeking to delay here, right? Or attempting to drag this out.
You don't feel that Mr. Bradford could meet your expectations in sales where he's at?
Not for Conway, yes. We do not feel that for Conway.
So you feel that your product will be sold in Conway, the bulk of it, and nowhere else? You're not gonna protrude over into Little Rock, Russellville?
Yeah, so obviously if a dealer opens up in Conway, they have the opportunity to make sales to wherever they can sell to, right? And Mr. Bradford has the opportunity to continue to make sales to people in Conway as well. But right now, the data, from what I understand, is showing that Mr. Bradford is not penetrating into the Conway market. And so there's opportunity, untapped opportunity. And not only, but one of the main existing dealers is C2 Power Sports, who is the candidate who owns a Polaris dealer in Conway. And BRP's market share for these vehicle lines is dismal compared to the opportunity in the industry available for these sales. Polaris is doing much better from a market share standpoint because essentially BRP's Can-Am lines are just not being sold then.
And Brandon, I appreciate that, but again, we're kind of getting more into.
Yeah, we're getting
more into the
we
hearing
are
subject
hearing
matter,
part,
so
not-
we really just need to focus.
We just need
Okay,
to
I'll make
focus on,
That's what needs to happen.
Yes, sir.
If I may, before intuiting where this may be going. Part of the schedule too, right, was always agreed because I have vacation planned in the middle of June. Where I'm gonna be out of the country with my family on a long planned trip. So we built dates to accommodate that, right? Our expert report was due originally May 30th. We shifted that date to June 6th. Then what happens is Bradford serves its expert reports, and those are gonna be due The schedule showed June 27th, okay? My trip, I leave June 6th, I get back the 25th. So it was all designed to accommodate me being out of the country for an extended period of time, which I realized. But that was gonna be when Bradford does its work to have the expert reports done, right? This was all built on pre-existing schedules, and BRP followed it. There's one party here who did not. And now they're seeking to just say, for really no valid reason, we just want to keep shifting the dates further. But if the commission is inclined to allow some additional amount of time, what I would posit is that the parties come together and work out in some form of agreed schedule if the commission is thinking in that direction. We obviously oppose that, and we have not changed our position, but I do not want the commission to set dates then that really put impositions on pre-existing schedules for council and the parties.
At this point, I think it would be appropriate for the commission to do one of a few things. So you have to buy that, you don't have to do this. If the motion would like to be made, you can make the motion, it's seconded, you can continue the discussion amongst board members, you can ask questions of council, and then you can ultimately take a vote on it. If you're not ready to make that motion, you can continue the discussion and you can ask questions of both sides. But whether the motion is made or not, you still have the opportunity to ask questions as far as how it's going to be prejudicial to the side.
I have a question. If we extend the deadline for fact discovery, but don't change the rest of the schedule, it sounds like maybe that's kind of been done between the two parties already. But if we wanted to officially extend that deadline to, say, June 10th, could we leave the rest of the schedule like it is? And
Yes, you can.
we're not talking about whether the leadership in Conway's viable or not. That's for a later.
Yeah, that's for a later
So
discussion.
all we're talking about is whether this, I personally hate to see us kick the can down the road. Thing's been going on for well over a year now.
Would July 18th work for both parties? If we continue it, would both parties be available? You think you could get that negotiated between the two parties to where?
February was done.
I understand what the request would be that
July 18th would be when you all would, that's the date that you need to get your discovery and all the things done by. And then we will continue in the end of September with the hearing. Correct? Is that right, what we're saying, or is that not?
I would make a motion that we extend the deadline for fact discovery to June 10th and leave the rest of the schedule the same.
All right, what about the expert reports?
Yeah,
Schedule is.
I don't think that we're gonna be.
Well, does one have anything to do with the other?
It does.
I mean,
Yeah, it does.
it does. The whole point was to have the fact discovery period completed before the experts, but we're already in an overlapping period now because we accommodated an extension of the schedule when they asked. So we're now cutting into our expert report time, our own, on our own by agreeing to accommodate their late served requests. And so this just kind of continues that and impinges our, ability, if fact discovery is continuing to go on, our experts aren't gonna, have the benefit of that. And the whole point was to allow them to have at least some amount of time with fact discovery being done. It's possible we could live with it. Maybe we could get an extension on, maybe we can work through an extension on our expert report so that it works and tighten up their deadlines for their expert reports. But again, right? This was all designed, you know, the whole schedule was worked out with intent not to be just like loosely not followed. There was meaning behind the dates for real. And this is now throwing a big wrench and disrupting those plans, obviously. We've been reasonable. We have allowed extensions, we have allowed accommodations. He laughs, but I don't know the basis for why he's laughing at that. We have, and so, right, this is now throwing a wrench into the.
Again, the board has a lot of options as far as how they want to do this. Right now, I believe Bradford has sent out 2 discovery requests. One may have been answered by VRP, the second one I don't believe had been extended and request, extend the time to allow VRP time to respond to those 2 discovery requests, which would prevent Bradford from submitting a 3rd discovery request. You could have just a date that you'd like them, but that would allow Bradford to continue to produce discovery requests to VRP. We have a lot of options as far as that day. Get that.
You know, I think
I made a motion, is there gonna be a second? But I'm saying, I'm listening to your options, and I'm not liking the idea of keeping the can down the road. But I feel like the commission's been put in a position where we're dealing with a date that two attorneys can't work out. And this is no disrespect, but we've all got vacations planned too, you know. And what I'm saying is, if we give you some time, we don't want to keep on changing or whatever, get it settled, and let's move on. Am I making any sense? Okay, well, did your motion cover that? Well, the only date I was talking about extending was the date for fact discovery and making that June 10th. And leaving all the rest of the dates on the original schedule.
And allow Bradford and VRP to work out the extra.
Yep.
Yeah.
I think I can live with that, but that's not ideal, and I'll be out of the country starting June 6th, but.
But you got
Right, I've got real attorneys in
You
there.
got
I'll be out of the country too, but I haven't complained about that.
Well, the way I'm looking at it, the way I'm looking at it is, all these dates are just dates. I think we need to plan to do the hearing September 30th through October 3rd. And I don't care how you all solve the rest of that problem.
I'm with that.
It's just a matter of, we need to get this over with. And you know, that's the one date I don't feel changing is the September 30th through October 3rd hearing date. You get that in form of motion. Well, I'm meandering, so.
Well, there's no second to your motion, so it dies.
Okay, well,
When's our date? So I'm clear. September 30th?
Yep, so.
that's the date it's set in the
Go
hearing.
ahead and set with that.
You're for that in the
October.
I guess what I'm proposing is that we allow them to change any of those other dates, but not the September 30th through October 3rd date. We go ahead and plan to have the hearing then. I think that's a better way to put it. None of these dates don't mean anything to us. But we need to have this hearing, we need to get this over with.
But I think that's what the controversy is between the 2 attorneys. They've tried to extend the May 9th date. They've extended it to the 19th. They're asking for, one side is asking for another extension, the other side is saying, no, I can't agree to that. So they're asking the commission to decide.
Okay, then I'll go back to my original motion. Let's change the fact discovery deadline to June 10th and leave all the other dates the same.
There's second to the motion.
Second. Jimmy Jones. Oh, Scott Little.
Thank you. It's been moved and seconded to move the fact discovery to June the 10th and leave all the other dates as is, arguing on September 30th, October 3rd. Any discussion?
Could I just make one question?
Sure.
Clarifying point. Do you want the discovery to be completed by June tenth, meaning that the next discovery request has to be submitted 33 days prior?
I'm no lawyer, I don't,
That's typically how it's done in civil court.
I'm just trying to figure out a way to get this over with.
So it just
For
needs
the
to be
hearing on
completed.
September 3rd.
Need to be completed by June the
I
tenth.
mean,
All right, is that all right to
That's
redo
fine.
that motion?
Yeah.
All right.
That's what our council
I
advised.
think that would be more clear.
Sorry, I knew I probably hadn't said that right.
So I just want to make sure I understand what the.
We are, the motion is to move have the fact discovery completed by June the tenth. That, all right with everybody? There's a second to that motion?
I
Yes,
second that motion.
right,
And then,
right. We just needed that word completed in that motion.
He's agreeing with what I said.
Well, that would be up to you. You'd have to amend the motion.
I'm agreeing with what our council
Read that.
advised.
That's right. Amend the motion. Scott, you're amending your original motion.
Yes. With the advice of our council.
And you're seconding.
I'm saying.
We need to, vote on the amendment to amend it to complete it by June the tenth. That's been seconded by Jimmy. If they're all in favor of the amendment, say aye. Those opposed? Now we're gonna go for the motion, which is to move to have the fact discovery completed by June the tenth, 2025. All those in favor say aye. All those opposed, same side. Motion carries.
Brandon, what was your question? Did that clarify for you?
I just, to be clear, that June tenth means completed, meaning whatever discovery requests are written are out there.
Correct.
But if there's nothing going to be new served, right, because it won't be due until after that deadline, is that what the intent is?
Fact discovery is completed. That it's, yeah. Completed. That's what I think the commissioner's intent was. Correct?
Correct.
Yes. Yeah, it says the original thing was parties complete fact discovery. Instead of May 9th, we changed that.
To June the tenth. We did not vote to decide that we need to stay on our original schedule, or that would be what y'all do. That part of that, we have no,
That's already been.
It's been agreed to, so-
Change.
Right.
In the action.
okay, thank you.
That's the only thing.
Everything else,
One
we have to.
One clarification, sorry, to be late, our expert report has been agreed that it's instead of May 30th, it's June 6th is the deadline. That's not reflected in the schedule you're looking at, but that's reflected based on the back and forth between the parties.
Okay.
I got that. I just want to have a hearing on the 30th. Get this over with. You can adjust those other dates any way you want.
Different about it. I have gone on to their next, under B, legal briefing. River Life versus General Builders, that's a.
Yes, and I'm gonna let Mary kind of touch on this. We discussed this at me. So this is the one that, if you recall last time, and play with it here last time. So there is benefit here, and we'll talk about it a little bit, but we did approve to set a hearing. For this, but it was so far into the future, the commissioners kind of all indicated they needed to check their schedule and figure out what days in July, what time frame in July would work best, and then we can come back and decide that. So that's really what we need to decide today with Aaron is what dates, either early July, late July, because I know some people said they had some conflicts in the middle of July during my normal meeting time, so We need to decide what date in July we want to set this hearing for, so that Aaron and I can get the next hearing. Within. Hopefully y'all had time to think about that, but I know Scott said he had something.
13th through the 16th, I'll be totally anyway.
Okay,
That will be the last week in July.
the last week in July, you're available. or
No.
Not available at all.
No, no.
Right, so. We have 7th through the 11th, 14th through the 18th is normal course, and then you're talking about the 28th through.
Correct.
Okay.
And
So,
well, I mean, when it's shut down, but then that-
and I think late July too. depending on- So what is, Jared, Mr. Taylor, and Mark?
I'll be here in the week of the 4th. Yeah, but
Okay,
First week of August.
we can't. So that would be the 7th. So you're not available. Yeah.
And I'm not available the 5th through I won't be back until the 17th.
So it's
starting to sound like the 20.
whatever the 21st or the 25th is the best option.
Bell ring.
Joy's not out for that next year. Right. I'm good. Pretty good. Michael, if we do the 21st and the 25th, are you available that week?
Yes, I can. The 25th would be my only potential conflict, but I could probably work that out. I can do the 21st through the 25th.
Well, we'll probably start it out by setting just a day during that week. We'll see if we need more time after that. Clay, what about you? What about you the week of the 21st and the 25th? Are you available? All right. I'm not sure. So if we set it for.
It'd be that Wednesday. It's all day. I can't all day.
Do that one day.
I can do the morning. I can do that.
I mean, we can always continue to the next day. What do you think here? Set it for like. Start out with the 1/3 and 24. See where we go from there. We'll probably, I'm sure. We'll have to get past the-
Yeah, I'm good. Actually. So
Do we want to move the regular meeting to the 16th? It would be the normal.
Yeah, go down to the next.
We can,
That's
not good.
And just have the hearing.
Bus or is that?
Yeah, it'd be hard.
But
So either of those options.
You want to
Make a motion to move the regular meeting to the 23rd and we'll just schedule it for that day, because that seems to be the consensus that everybody's available. Mr. Wood is not available in the afternoon, but we can always continue.
I know, I'm feeling that way.
Oh, you can.
I've looked at the first one.
Okay. So, yeah, can you make a motion to set it, the meeting and the hearing, we'll just move the meeting to the 23rd and set the hearing for that day.
I move that we move our regularly scheduled meeting for July to the 23rd of July. And that we also set the hearing date for that day.
For Gentry Chevrolet versus.
Gentry Chevrolet versus John. Carol Tyler, second. Okay, Longo's got a little bit.
Okay, it's been moved and seconded to move our regular meeting date to the 23rd of July to the hearing scheduled that day of Gentry versus. We'll see. Whatever it is. I'm sorry, I don't have it in front of me.
Gentry Chevrolet versus.
All those in favor say aye.
Aye.
All those opposed, same sign. Motion carries.
And that leads us to our final legal briefing matter, which we need to address. Now, if you will recall, this was also one that you voted last time to set for hearing at our next meeting date in June 18th. Aaron and I sent a hearing notice out to Mr. Scotty Walbeck, the owner of Icon Hospital. Started on him, he got the hearing notice. We sent that out last week. And immediately after we sent that out, Mr. Walbeck went online that night, Friday night, what was that, the 16th? On the 16th of May, and applied for a license. So he did finally apply for a license after we sent out the notice of hearing. However, as Alexis is gonna go over for you real quick, he is still deficient on a lot of the required information and documents. And obviously, we've already sent out the notice of hearing. He's been in violation now for 4 months. That we know of. He's been in business for 2 to 3 years. I'm gonna let Alexis briefly go over what he's missing, and then when it comes back to me, I'm gonna tell you what I think would be appropriate in this case, and then let the commissioners decide. Aaron's also gonna chime in, but this is a situation where I feel like we still need to have a hearing. If we don't have a hearing, there's some options that Aaron and I enjoy can discuss with him now that he's actually replied. Alexis, you want to kind of give them a brief update on what we're still lacking from him, and you talked to him this week on the phone too.
Mr. Walbeck submitted after close of business on the 16th, so I was unable to see his submission until Monday, which was the 19th. When I reviewed his submissions, there were quite a few errors when it came to general information, the CBA name, branch information, his personal information in different locations on the application. He also failed to attach any dealer agreements. He failed to properly list his facility size and the measurements that are required on that application. Because there's no dealer agreement, there's no relevant market area statement. He did not have proof of insurance at the time. He attached an application for insurance, which was done on May 14th.
Of this year.
Of this year. He listed a non-licensed manufacturer as one of the products he's going to sell. And we did have an issue with him in the past with a manufacturer that we discussed in our last meeting, and he did not put them on there. I didn't say that. And then the final thing he was missing was colored photographs. And that was all sent in a message. I worked with Director Pace to send him a proper rejection notice so he would know each and every individual reason, and all of these things were included in that notice to him. Ms. Sexton was out on investigation that day, so after I rejected it around 1 p.m. while I was on the phone with her, he gave us a call. So I discussed with him about 1:10. He called and let me know that he had taken photos of his location and he was unable to get those photos from his phone to his computer to upload them to DLP. And he wanted to know if Ms. Sexton had the photos that she took when she came out for that initial site visit a few months ago. She informed me that she did have those photos. I let him know that. I then informed him if he made all of the changes that we were asking for, I could assist him in uploading those photos after he resubmitted. While I was on the phone with him, he told me that he had made all the changes he needed, but then needed my assistance in getting into the profile, and he resubmitted. I looked over everything. There had been 0 changes made, and since I had previously told him I would upload the photos, I did so, and I sent him a secondary rejection notice, and all I took out was the part that he needed photos. Everything else in the notice remained the same as the first. He has not resubmitted, and it's been 2 days since I last sent him that.
And just to be clear, we discussed it last time. We know he's still in Bentelli LSPs. He's still selling Bentelli LSPs. He's not authorized to sell Bentelli LSPs. He didn't put them on his application, but he's still selling. So there's a lot of unanswered questions with him. He did finally apply after 4 months of us prompting and trying to get him to apply. It took us sending him a notice of hearing to get him to apply. So he has paid the license fee and has applied, but he's still deficient on most of the required information for us to even consider licensing. We're still working on that. But we did obviously send him a notice of hearing, which he got for June 18th, next month, at the regularly scheduled meeting. And Aaron and I have discussed this. We have the ability under Rule 2 to approach him. Aaron and I enjoy and try to get him to agree to a consent agreement short of us having to have a hearing that you guys can just approve the consent agreement or not at the next meeting. But Aaron, do you want to talk about what we could do with that if we discuss the service?
Yeah. So one of the options that we discussed is as part of the consent agreement, in addition to getting the license and all of that, having him appear at the next meeting. So if the board, if the commission has any questions as far as why it took him so long, what he was waiting for, that sort of thing, you could ask that directly of him before you agree to accept the consent agreement. That would not be a hearing. I would not be able to ask questions unless, of course, the commission asks me to ask the question. But basically, the issue before the board at that next meeting, if the consent agreement has been signed, should be if the commission wants to accept the consent agreement or reject the consent agreement and then have a hearing the next month.
And, you know, depending upon how he answers, if he shows up, we can always just have to hear, set it again for the next month, as you said. But, you know, I feel like we have to, he still needs to appear. There's still a lot of things to answer questions, and I'm not comfortable just issuing him a license, even if he gives us all the information without him coming to talk to you guys first. Kind of explain some of this stuff and make sure that we're doing our due diligence before we just give him the license. Since he's been less than forthcoming for this entire process. But the consent agreement, just to be clear, allows us, we can still propose a fine to him in the consent agreement up to, what is it, $5,000. So, short of having a hearing, and we can set in the consent agreement kind of terms that he has to be by June 18th, including the appear before the commission. So there's a lot of things we can do with that. But I'm leaving that up to you. But I wanted to present that to you as an option. We do have that ability to do that short of actually having a hearing, since he has actually applied for a license. Fine. What's the question? Scotty Waldeck. Yeah.
We have a question.
Yes, but once we have, yes, sir.
His distributor, is he not licensed in the state?
Which one are we talking about?
Waldeck, where he's in the LSV vehicles?
Yeah.
That can be one of the questions you ask him, for assuming that he's still selling. We would preemptively go down and confirm that he's still selling with Intelli before the meeting there.
Is Intelli licensed in the state?
Intelli is licensed.
Okay.
Oh, I didn't.
The issue is not that Intelli's not licensed. The issue is he's not authorized to sell it.
Is he authorized to sell anything that we're responsible for as a commission?
Yes. Evolution, he has an agreement with Evolution LSPs, right? Roxy is not licensed, so that we've got to get them.
Speaking to him, he has been told that he is not authorized to sell Intelli. He submitted a dealer agreement for Roxy, which they do not have a license. That company does not. Then Evolution.
They're based out of Alabama.
Yeah.
Yeah, they don't have a license.
Evolution Electric Vehicle. He got a dealer agreement with them, and that was after some of Ms. Martin's initial speaking with him. So he had product, but had not signed the agreement prior.
Is there
to when he got that. And then Icon Electric Vehicle, we have reached out to them, and they have not started or denied.
But they are
Given
licensed.
him-
Icon is licensed.
So the only one unlicensed is Roxy, which he gave us a dealer agreement for, and the date on that is also would be something we could discuss.
So, yes, he does sell product that we do have a license to distribute.
He's been in business for at least a couple of years. Has he ever had a license issued by the Lord?
That's part of the issue. He's never had.
It's located in
No, hospital.
Virgin Park.
Well, I'm trying to make sure everybody, Michael, do you have any questions up there? I see you shaking your head a little bit.
Nope,
No. Does anybody else have any questions before, I know Jimmy has a motion, he's ready.
We can discuss it after. Yeah, we're find out more about what he goes about. That's Jim Jones for us.
Got it. There's a second.
Darryl Snyder.
It's been moved and seconded. We invite Mr. Paywall back to our meeting.
Okay.
But
Do we want to,
do we, yeah,
address the consent? Are you okay with Aaron and Joy and I approaching him about the consent agreement and conditioning?
after we, get together and see it and enlighten him about there would be a fine if he doesn't do some of these things. Well, we just kind of
We may
added to it.
Yeah.
Yeah.
Well, I'll make a motion that y'all read it.
Okay.
And you can't help, then you bring it. Oh, is that the commission in? Let's give me time. I may do some wonky stuff, but I'm gonna let you do that. Well, they gonna be really. Y'all can handle what you want.
Can you take the first motion off the table?
I'll take it off.
Move to the second, we take the first motion off the table, all in favor, say aye. Okay.
Aye.
Another motion.
I'll let Scott do it.
Thanks.
Oh, no, I just make a motion and you gotta put it in the commission. Okay, and. Well, so,
At the June 18th meeting.
okay. Not taking it here.
Right. Then
You're
moved,
up.
seconded, that we, invite Mr. Spaywell back to the June 19th meeting to discuss the issues that Parker Summer Vehicle has. All those in favor say aye.
Aye.
All those opposed, same sign. Motion carries.
That'll work.
All right. Actually, we have some items, voluntary license surrender, it's noted in your agenda. Part one Honda, Ideal RV Center and more equipment and Ford Company.
So one question on that, Mr. Wood.
Oh, yeah.
I know we generally do the joint, like, that, what we call it, the summary approval of all of them.
Right,
So obviously Michael is, he's
right,
done doing away with the toy equipment store.
right.
Aaron, I don't think he doesn't need to be involved in the motion to approve that, right? No, he would have.
Yeah.
Okay, so we need to do that separately
Okay.
so that we can,
All right.
the first,
The first two are Heartland Honda and Ideal RV Center.
Heartland Honda, just so everyone knows, that's the original owner, that we bought from, so this is surrendering their old license. And then Ideal RV Center, I touched on this last time. This is Mr. Gibson, and you can thank John for getting this, because I don't think we would have gotten it otherwise. Mr. Gibson, an elderly gentleman, very nice, but he's in Mountain Home, Arkansas, way up there, almost Missouri border, he's North Mountain. And he is no longer selling any products we license, and I talked to him about it, John's talked to him about it, Lexus talked to him about it. And we finally got him to come around to, look, get your used car dealer license to sell this stuff and stuff. Surrendered once, so that's why he's surrendered, because he is not selling anything currently. Regular. So we can't just issue him a license just to. So that's why this would be.
License surrender.
Yeah, license surrender, thank you. So that's those two, and then we'll do the. Mr. Moore's license.
I wondered about that. So I entertain a motion, for voluntary license surrender. Of the list 1 and 2, Heartland Honda and Ideal RV Center.
Motion to approve it, Michael Johnson. Second, Scott Wood.
Been moved and seconded to approve the voluntary license surrender agreement for Heartland Honda and Ideal RV Center Inc. All those in favor say aye.
Aye.
All opposed, same sign. Motion carried.
Thank you, and that brings us to Wix Equipment and Toy Company. I'll explain this for Michael, so he doesn't have to. This was Michael's power sports store in Conway. He's had for a while, where he was selling Suzuki Arctic Cat, Cryo, Intimidator, Spartan. He has obviously decided to do away with that business, so he's surrendering his license, and there will be a actual new dealer that he's leasing that old location to that you will be seeing next week, or next month. Here, we approved the license for, so we just didn't have time to do it for this one. So that's what we're asking you to approve there. And does Michael need to just say he's refusing himself with the record of this?
Check. When you announce the results, you can just announce the record.
All right,
Perfect.
so I need a motion for page 25-037.
Motion to approve.
Second. Mr. State, here.
It's been moved and seconded to approve the Lloyd Equipment and Toy Company of Conway. All those in favor say aye.
Aye.
All those in favor. Second sign is true. It has been moved and seconded and approved without the, with Michael Lewis recusing himself from the motion and the results.
Sure.
Okay, we're on the automotive.
That brings us to the grand finale here. Well, that would take very long though.
They're on, under section, what it is, B.
Yes. So what we have here for the commissioners, and Alexis sent out to everyone the full grant application package. She sent you a link to the shared folder because there was so much documentation. That's not something that we ever really email to you because it's just too big to go through. For everyone to review those, but the list you have in front of you is all 13 applicants. The two that are highlighted in red are the ones that per the committee that Alexis and I met with in early May, which includes Division of Higher Education, Career Technical Education, Office of Skills Development, all the directors, basically division directors from those agencies. They handle grants all the time, so they're used to this. Their recommendations back to you basically are all the ones that are not highlighted in red. I highlighted ATU Ozark, and these funding amounts all add up to 250. So that's the fully appropriated amount we're allowed to award per fiscal year. We can't go beyond that. So basically what we did here, just to explain why these two are excluded, because we went over this in detail. We had, what was it, like an hour-long meeting with them about this. You'll notice we have two applications from Northwest Technical Institute, right, for the ASD and visa program. Last year, we awarded both of those programs from Northwest funding, both. So this year they both applied again. Well, we also had 4 new programs apply this year that never got funding. So we just had to make some hard decisions to try to make sure we can get all those people full funding since they've never been funded. So what those people said, and I agree with them, and again, this is ultimately up to you, but I agree that look, we can still fund Northwest, we're just not going to fund both the AST and visa program. So Northwest AST is still getting their 17,466 in funds they requested. We're just not going to fund the other program. So Northwest is still getting funding. Again, they got full funding last year for both. Okay. Huntsville, the other one they decided not to fund. Again, Huntsville High School, we also fully funded last year, but we got them to do installer lift, or what is a lift? I think a big lift. So the rationale for this one, all of those directors told me that, you know, they have a good program up there, but their attendance is really dwindling, and they have had some overturn in basically the superintendent, and a lot of stuff in admin of the district. And it's kind of the impression from, those folks that this program may not be around. So we gave them full funding last year, and that was one they decided, look, maybe this time we leave it now and focus on these other programs that have never gotten funding before. So that's why they made that decision. And again, Huntsville High got full funding from us last year. The 4 new programs this year, just so you know, that we have not funded before, that to my knowledge, you got North Central Career Center, which I believe is in Leslie, up there around Clinton somewhere, in North Central Arkansas. Serves high school students all around that area. That's kind of Clay's area up there. Then ASU Three Rivers Career Center, that's the one down in Malvern, right, Margie? That's Malvern. University of Arkansas Rich Mountain, which is over there in Mena, is it Mena, right? Okay, and then the ASU BB Searcy campus, all have programs. We haven't funded any of them in recent years at all. So we wanted to give them full funding, and they're getting full funding per the recommendations of the funding. And then these other programs are all good programs. Now, with the highlight on ATU Ozark, I highlighted that to notate, and this was from, and I knew about this from talking to them in person last year when I went up there to visit their program. They have a great program. They have a welding school, they have an automotive service school, and they have a collision repair school. So we cut down their request amount to get us in that 250 window to 28,172.61. We cut it down by a little over $1,100. And here's the rationale behind that. Okay, they are actually getting a Division of Higher Ed grant for $2.75 million over the next couple of years to do improvements to their school in general, to the program. And I know Mike probably knows about that. The main campus. But they're doing improvements with that grant. Now, that grant is not specific to the AST and the programs, but they're using it to improve the buildings for AST. So that's why we were like, well, they can afford to be cut down a little bit from their full funding request. But this is still going to help this funding amount is still going to help their collision repair and their AST programs, both of them. So it's not just one program. But other than that, those amounts, cutting out those two, we got it to exactly the 250,000 that we're allowed to award, and pretty much everybody on the list is getting full funding they requested, except for ATU Ozark, and that's only by a little off. We were able to do that by cutting this. So with that, I know everybody had a chance to look at everything, but if anybody has any questions, let me know. But basically, this is the funding request that committee recommended to all of you for approval for this fiscal year. And obviously you have to make a link improvements. And Alexis and I and Margie are very good at getting those funding points out pretty quickly after you guys approve. So, but we do have the files there in the middle of the table. Somebody needs to look at one for whatever reason, but we try to make that even before.
And the collision repair part of it, we always look at that pretty closely. Sometimes that I think that worked out.
Yeah.
Okay.
Yeah.
Some of it didn't qualify. It's a long time ago. I think they all understand it now.
Yeah.
What is your pleasure?
Make a motion to approve the recommendations.
There's a second.
I'll second that. Michael Moix.
Michael Dickinson.
Go for it, Mike.
Thank you.
It's been moved and seconded that we approve the 2025 Automotive Technological Education Grant Program applications that are listed here. Minus the ones we just, I'm not gonna read all their names. No, I think we've gotten it all down, and thanks to the committee for getting all those in favor, say aye.
Aye.
Those same time, the motion for that carries.
Yeah, we tried to make it as easy as possible.
Yeah.
For you guys. So we
Appreciate
spent
that.
a lot of time on it with those
Well,
folks.
we understand, we've been through it.
We didn't want to have to go through every single thing.
Okay. We have C to this, the ELP system license application that.
Yes, and I wanted to highlight this and show it to you guys. So This is what we talked about last time, that Alexis and I kind of talked about and really determined that we need this on all manufacturer and distributor license applications going forward. Because we've discovered that we have some issues with getting manufacturers and distributors to properly report all of their representatives with the way the system is set up currently. So this form has been uploaded into the system and will be required on every distributor, manufacturer renewal or original application going forward as a required document. And you'll see it has a back too, so there's plenty of room for all of them. But this basically allows us to keep track of, okay, who are your current representatives? These representatives, depending on the company, tend to change from year to year. It's very hard to keep track of them, and the onus is really on the company to report it to us in terms of who's working for them to say and who's not. I anticipate that we will have a significant number in the next year that we will not have known about before that will get licensed because of this, and I anticipate that revenue figure could be anywhere from 20 to 30,000 or more, just based on, I mean, for instance, I'll give you an example. Alexis was talking to Honda when we were licensing a new Honda dealer, and we discovered how many representatives working in the state that didn't have a license that needed one.
About 8.
So anyways,
This will take care of that.
this is our effort to take care of that
Effort.
and make sure it should clamp down on most of that, and it requires those companies to let us know, okay, who's currently working.
Can you put in parentheses, this has to be, no.
Well, it's when I say it's a required document, I mean,
Right.
you cannot complete the application without
Oh, good.
uploading the document.
Perfect.
So
That's perfect. I'll let you do it. Okay.
I'll let you know what it's at. And I think, you know, the old way we did this before the new system, I think they just had them send it in a big packet and they just attached everything to it. But even then, I know we were still missing out because we weren't really requiring some benefits.
Right.
So, this should take care of that. So I anticipate being able to report back to you next year after we complete renewals and tell you that we've got a lot more reps that should have been licensed there. Yeah.
Perfect.
But this was all, by the way, this was all Alexis, she designed this whole thing.
Congratulations.
Very good job. Thank you, Alexis. And, I can't remember, did I put it, I mean, you guys have already approved this form, so you don't have to.
I was gonna say, I don't think we have parentheses, do we?
No, you've already approved this. You've already-
It does have a little.
Yeah, I should. You-
Well, by word of mouth, we love it, so,
Okay.
thank you. I think it'd be great.
And with that, I close because we don't have anything else on the agenda to address. And the only thing I will say is, obviously, yes, we will have a meeting next month. Last meeting of this year, and we have the licensing
Yeah, with what's
issues
going
to
on.
address. And Aaron and I will undertake efforts to get Mr. Wall back to the table, and hopefully we can work that out. If you guys have a consent agreement to.
We had a lot to think about today, and I appreciate y'all. Appreciate every one of y'all. I screwed up any of those motions.
Sorry, I confused you.
No, it's fine. We did good. With that, anybody have anything else to bring before the group?
Scott, we're gonna move with adjourn.
Thank you, Scott.
Second, there we go.
Moved and seconded, we adjourned the meeting of the Office on Baker Vehicle Commission on May 21st. All in favor, say aye.
Aye.
Those same signs, motion carried.
Thanks, Michael.
Thank you. I appreciate it.
Recording stopped.